Let me reflect we are back in session. Parties and council are present. All members of our jury and alternates are present. Our witness on the drawing is back on the witness stand. And people may continue your examination.
Ms. Ryan, when we were here on Thursday, I asked you some questions about cases you testified in previously about testifying on a high-profile case. Follow that line of questioning?
Yes.
And you initially, I asked you if you testified to that basically, and you said I didn't. I don't think I said that. I don't know. Maybe I did.
Right. I think initially I thought you were talking about in this particular case, did I say that? So once I had a moment to think about it, I realized I probably did say that when questioned by a district attorney in the past.
In Kern County.
Okay, see, I was thinking it was in San Diego. So it's, I believe you for sure that I probably did say that.
Okay, well, I don't get to do the testimony. So I'm asking you, did you say that?
I don't have a specific recollection.
Showing you transcript from People versus Morales, Kern County, September 15, 2010. This is page 87. Feel free to scroll through whatever you want to scroll through.
I mean, I don't even remember this case. So, okay. Okay, sure.
Recollection correct?
Yes,
You testified to that previously.
I did.
So when you said I don't think I did, your recollection was incorrect.
Objection, argumentative.
When you said I don't think I did, was your recollection incorrect?
Objection, argumentative.
Also, when we last left off, I was asking you to find a report by Heather Radcliffe where she had swabbed the trooper for DNA.
Yes,
Recall that?
I do.
Were you able to find that report?
Yes, I found a report dated December 12, 2013, authored by Heather Radcliffe. I did misinterpret what the report stated because looking at the report, it appeared to me that she photographed, performed latent print analysis, and collected the DNA swabs. But there is a line saying she received those DNA swabs from someone. So I was incorrect in that she must not have actually done the swabbing, but that report exists on that date authored by that particular criminalist.
Okay, but that report does not say that she swabbed the trooper for DNA.
Correct. I believe it says she received certain items from a detective.
So my question was, does it say that she swabbed the trooper?
It did. I'm sorry. No, it does not, and I was incorrect in that inference.
Okay, so your job is to try to help defense attorneys find errors in what the government has done,
Objection, argumentative.
right?
Right, and specifically with DNA testing, I'm not a latent print expert or crime scene specialist.
And in this case, that's what you were trying to do when you wrote that she's the one that swabbed the trooper.
Objection, argumentative, as performed.
Right?
Could you repeat? I apologize.
Sure. In this case, that's what you were trying to do when you wrote that Heather Radcliffe swabbed the trooper for DNA.
What do you mean by that's what?
Okay.
That I was trying to point out an error? Is that
Yes.
what you're saying?
Yes.
Oh, so there wasn't anything wrong with her. If she had swabbed the trooper, I wasn't pointing that out as an error. I was making a comment that, you know, in my understanding, and typically you do latent print analysis first, you have to, because
You wrote this under a section called evidence issues.
Your Honor? Yeah.
Finish your explaining your answer.
right, so you have, if you're going to do latent print processing, you have to do it prior to DNA swabbing, because once you swab something, you would destroy a print. So my comment in my report was, if the person who who tested for latent prints had used the same brush in multiple different areas, you can pick up DNA and transfer it from one location to the next. I was merely pointing that out, that DNA can transfer.
Okay, so your testimony today is that you're saying that if that happens, then that DNA could have transferred.
Yes, exactly.
Your report actually reads, after the latent print
I
processing.
object as to, now this would be hearsay, what's in a report.
Overruled.
Your report actually reads, after the latent print processing, the DNA swabs would have been collected.
Yes, they would have been collected after latent print processing. That's the proper way of doing it. If you were to swab first, you cannot do latent print processing.
But you swabbed for DNA already.
I didn't swab.
No, I'm saying in the process, you're swabbing for DNA first.
I don't understand your question.
You wouldn't swab for DNA first?
No.
You would fingerprint first?
Yes.
And that would move stuff around?
It could if you use the same brush in multiple areas of a vehicle.
Who actually did the swabbing?
Frankly, I don't know. I wasn't provided with that report.
Okay. You weren't provided with any reports from San Diego County?
No.
Okay. Well, your job as a scientist is to be as thorough and accurate as possible, right?
Objection argumentative.
Overruled.
Yes, and specifically with DNA testing. All of the DNA testing was done by San Bernardino County. That was what I was hired to look at. So these particular reports were included with the DNA testing reports.
Are you done?
Objection argumentative.
Overruled.
Yes, I am done.
Did you call the person who actually swabbed for DNA from San Diego County?
I don't know who swabbed for DNA from San Diego County.
So that would be a no. You didn't call the person who swabbed from San Diego County.
No, I did not.
You also wrote under evidence issues about Blue Star, right?
Yes.
And in fact, in the very next paragraph, you wrote that Blue Star is a very sensitive presumptive blood test that can detect blood diluted in the thousands or hundreds of thousands.
Correct.
Where'd you get that information?
How dilute Blue Star can detect blood? Is that what you're asking me?
I'm asking you where you got the information that Blue Star can detect blood diluted in the thousands or hundreds of thousands.
Oh, from research articles, and I do use Blue Star or I have the capability, I did validate the use of it in my laboratory.
If you turn to let's see, it's your second to the last page of that. You said Blue Star is a very sensitive presumptive blood test and can detect blood stains diluted up to 1,000,000-fold.
Luminol and Blue Star are both very sensitive blood tests.
My question is, did you write that in your report?
Where are you pointing out? The very last page, is that what you're saying?
Second to the last page, third
Second to last.
section at the bottom.
Correct.
So is it hundreds of thousands or millions?
There are different articles that cite different dilutions.
Have you been to the Blue Star website?
In the past, I have, yes.
Isn't it true that Blue
Your
Star...
Honor, object. This is calling out for hearsay testimony from counsel.
Overruled.
Isn't it true that Blue Star says...
Objection as to the former question, isn't it true? Assumes facts, not evidence.
Sustained.
Does Blue Star's website have a dilution rating on it?
I don't know.
I would object if counsel wants to show her what's on the website to have her testify to hearsay. That's improper foundation.
If that's what council is intending to do.
She's been to this website before. I can ask her if she's been there. She's already testified she's seen this website before.
Objection, she's stating that she's not indicating that she relied on that website for that information.
Did you rely on your website when you said it was hundreds of thousands? Blue Star's own website?
No, I relied on journal references and my own experience and training in Blue Star and Luminol.
And then you did the same thing when you said it can handle dilutions in the millions?
Yes.
Would it surprise you if the Blue Star website only had 1 in 10,000
Your Honor,
dilution rate?
again, objecting that counsel's testifying to hearsay to get improper information for the jury.
Objection, sustained. Jury is instructed to disregard the last question.
Let's talk a little bit more about your background.
Okay.
You worked for Bodie for 3 years, 4 months, right?
Yes.
Worked for the Florida Department of Law Enforcement for 3 years, 6 months, right?
Sounds correct, yes?
In the Charlotte-Mecklenburg Police Department for 9 months?
Yes.
In Crime Scene Technologies for 16 months?
Sounds accurate, yes.
In Human Identification Technologies for 5 months?
I was a contract employee there, yes.
For 5
That sounds
months?
accurate.
In Advanced Serology for 2 years?
No, I still have that laboratory.
Okay, that's your own laboratory.
Yes.
Other than your own laboratory and your consulting business, have you had a position at any particular lab for longer than 3 years, 4 months?
Yeah, FDLE, as you noted, was probably 3 years, 6 months, and I would say that's probably accurate. I don't have generally when I testify, I say about 3.5 years, so sounds accurate to me.
3 years, 6 months?
Yes.
Have you held a position in any lab longer than 3 years, 6 months, other than your own lab and your consulting?
Other than my own, no.
You said that 50% of your current MVAC work is for law enforcement.
No, 50% of the DNA testing is about 50-50 at Pure Gold Forensics, where I do DNA testing. I do MVAC testing there as well, and that has all been for law enforcement. And then at Ryan Forensic Advanced Serology Lab, where I started first with the MVAC, all but 2 cases have been for law enforcement.
That lab, you just say you're doing law enforcement work for is in San Bernardino County.
Which,
The one that you said all but 2 is for law enforcement.
I think that's bad.
Pure Gold Forensics is in San Bernardino County.
It's in Redlands, yes.
And the lab in Redlands, what's the percentage work for law enforcement?
It's about 50-50. I don't have it written out. We're a fairly new lab, so we don't have a huge client list yet, but we do work for both agencies.
Now, as a consultant, we've discussed what kind of your role is, and one of the things you typically like to talk about or testify about is transfer. Is that fair to say?
Oftentimes, I am asked to testify regarding transfer, yes.
And the other thing is contamination.
What is your question?
One of the other things you typically testify about or advise on is contamination, right?
I'm sure I have, yeah. I would say transfer is definitely something I testify about more often than contamination, but it can and does come up, sure.
In this case, in your report, you wrote about where the plates were analyzed by Donjo.
Yes.
And you noted that the steering wheel sample was on one plate and diagonally was the known sample.
The known sample for Mr. Merritt, correct.
That's not unusual in forensic analysis, is it?
It depends on what lab you work at. Some labs don't allow knowns to be run on the same plate. But I would not say it's unusual. It just can lead to, it opens the door for possibilities of contamination. It doesn't mean it definitely occurred.
And you don't have any evidence that it occurred in this case?
Typically with contamination, we don't know if it occurs, right? We get the DNA results that we get, whether it's contamination or not, there's not really a way to tell. So I can't say one way or the other.
So you don't have any evidence that it did occur?
Other than the fact that those samples were adjacent or diagonal. No, it's not evidence that it occurred.
Because DNA doesn't jump from one plate to another.
Well, it was on the same plate. Wells that are very small and adjacent to one another, and if someone isn't careful, can misload the sample. If Mr. Merritt's DNA was introduced into one of the samples, it would look like his DNA was in that sample. We would have no way of knowing whether it was always in that sample or it was introduced in the testing.
But I guess my question was, it doesn't jump from one DNA to another.
Not without human intervention.
And you said in your report that the lab did not provide the curriculum vitae of the analyst in the technical review.
At the time that report was written, correct.
When was that report written?
This was written in 2017, August of 2017.
Did you ever get the curriculum?
I believe so. There were a couple of items that were missing, and so we did request those specifically and received the items that were missing.
Well, actually, when you say missing, it wasn't missing from the crime lab, right? From the discovery.
I have no idea. I know that I didn't receive it.
Now, when you talk about the possibility of touch or transfer DNA, you testified that it's never evolving subject, right?
It is, yes.
In fact, just a few years ago, you testified that the transfer of skin cells is actually questionable, right?
I don't believe, I mean, the transfer of skin cells is questionable.
Yes,
I would
secondary
say
transfer.
the secondary transfer of skin cells is questionable. I'm sure I said that sometimes it occurs and sometimes it doesn't, because that's still the case today. We know that sometimes secondary transfer occurs, sometimes it doesn't. In fact, primary transfer. Sometimes we can detect DNA from somebody directly contacting something and sometimes not.
Because that depends on a lot of different factors.
Absolutely, yeah.
The substrate being touched,
Yes.
the shedder status of the person touching it.
Yeah, that's a little, not controversial. There's some people who think that there are good shedders or bad shedders. Some people, that hasn't been proven yet. But there is definitely a concept of good shedders or bad shedders.
The type of contact, the duration, part of the contact.
The duration, what do you mean by the part of the body that's contacted?
Well, in other words, a hand versus a leg versus another body part.
I don't know if there's any specific studies that talk about differences in the amounts of DNA based on body part.
How about the person's fire, the duration, that's one of the factors, right?
It sure is, yes.
Whether there's been any cleanup.
Sure.
Whether the person's touching something, use gloves.
Yes.
And in this case, you have none of that information.
That's very true.
And so you're assuming when you say that maybe there was some kind of handshake or something, you have to make that assumption that the handshake happened.
Well, it doesn't have to be a handshake. There can be secondary transfer from objects as well.
Sure. But let's take the handshake scenario again.
Okay.
You have to assume that there was a handshake that occurred in order for someone else's DNA to go to my hand to some other object.
Okay, assuming that discussing a handshake, yes.
And you're assuming that in this case the trooper wasn't wiped out.
Well, yes, and I think that that's evidence supports that because there was DNA detected.
Well, does wiping down eliminate all DNA?
It would greatly reduce the amount of DNA present. Even with a dry cloth, it can greatly diminish and reduce the amount of DNA present. It might not get rid of every last bit of DNA.
Let's talk about F38 that was analyzed by Don Jones.
Okay?
That was 2 swabs from the driver's door handle, power window control, power lock.
Okay.
That's something that an individual would touch while they're in the car, roll the window up and down, right?
They certainly could, yes.
The lock or unlock the door.
Sure.
How much DNA was found on that?
I'm going to have to look through Mr. Jones's notes to find the specific amounts of DNA.
Well, would refresh your recollection, say, if I told you that he indicated a very low level of DNA on that, in those particular spots?
I would really like, that would not surprise me. I would like to look just so I have an idea of amount, if that would be okay.
Mm-hmm.
Okay. Yes, and I would definitely agree it's a very low level of DNA.
Oh, is that consistent with somebody maybe turned away?
It could be, sure.
There's also a low level of DNA, I mean, comparatively speaking, on the steering wheel.
And that was F36? It's a low level, but it's not unusual to find a lower amount of DNA from a touched object, so it doesn't, the other one was about 10 times lower than this particular sample.
The other one being the drugs inside door.
Yes, correct.
And you've never actually seen the steering wheel in this case, have you?
Photos. Just photos.
One of the studies you cited, the study you cited from 2013 or 14. I think you said 14, but actually it's 13 in this case. That's a study where they had a person rub a pen vigorously between their hands for periods of time.
Is that the Van Oorschot
Yes.
study? Yes. Okay. Yes, they had the person pick up 5 pens at once that had already been sterilized and cleaned, and they rubbed them for 5 seconds, put it down, and then the next day they did the same thing, and the next day they did the same thing.
Mm-hmm.
Yes.
And then a person took the pen and used it in normal use.
Exactly, yes.
Now, a pen's much smaller than a steering wheel.
Sure.
Right? And there's a greater surface area if I'm using a pen that's in contact with my hands, relatively speaking, than my hands on the steering wheel.
I don't think I would agree with that. I think that on a steering wheel you would have more of your hand in contact. I mean, the way I drive, I don't know.
Well,
Gripping.
they didn't actually follow the people use the pen. In fact, one person did the pen cap off, right?
They did, and they had to exclude that from the sample.
Right. So I'm holding my pen right now.
Mhm.
What I'm saying is, comparatively speaking, this is a small surface area.
Yes.
And then when my hand touches it, because it's smaller,
Oh, okay.
relatively speaking, my hand's in contact with bigger proportion of the pen
I would agree with that.
than would be on a steering.
I would agree with that.
You said you would expect that if the person drove the vehicle 90 minutes, that they would become the major contributor.
Right, and that's again going to be based upon the studies that were cited and the fact that it's a harder surface, not cloth, for example.
So you cited and several assumptions, right?
Yes, one assumption, as I said, was assuming that the transfer rate from a pen hard surface would be similar to the transfer rate on a steering wheel. So that is definitely an assumption.
And an assumption the person didn't wear gloves, right?
That was driving the vehicle? Is that what you're asking? Sure, yeah.
And an assumption that the person didn't try to wipe down or clean off anything they could do, right?
Right.
There was a study from 2016 that you actually cited in your report. And again, they were asked, there was one user who held an object, a relatively small object, and another user who held it for a period of time. That's the
O'Donnell? Yes.
study. And I think it was after 90 minutes or so, it was just barely a major contributor for the second user. Is that right?
My recollection is that that was kind of all the different objects summarized, and some of those objects were fabric surfaces. So 55%, regardless of what type of substrate, after 100, I believe it was 120 minutes is what they looked at, 55% of the second users were then the major. And again, that covered a variety of substrates.
Okay. So across the broad range of substrates you can have, it's basically a little more than a coin flip. The second user would be major.
For cloth substrates, there's a difference. That's kind of the point of both of those articles is they're finding, in the first one, they're finding, harder substrates you see, or non-porous substrates, you're seeing a higher transfer rate. That second contributor starts appearing as a major contributor sooner than softer surface. They used a cloth bracelet as one of their soft surfaces. And then that was supported by the 2016 study, where there's a higher transfer rate for the second contributor, or the second user, for the non-porous objects than the porous objects.
I mean, the question is basically a coin flip after 2 hours across all the substrates.
Across all the substrates, yes. Substrates, yes. It was 55% of, I think it was 200 some samples, yes.
55% of 200 samples. Held for 2 hours.
Yes, that was the longest time period tested.
Let's talk just a little bit about the MVAC. You testified on Thursday that there's a larger percentage of MVACs that are being used by law enforcement agencies. Where did you get that information
From Jared Bradley, who is the, I don't know his exact title, CEO, owner, founder, whatever you want to say, of MVAC systems.
Well, MVAC actually provided documentation in this case, right?
I don't know. I think they provided some validation studies, perhaps. Sure.
Thanks.
Oh, I'm sorry.
That's usually my job, but that's okay.
I'm trying to be helpful. I apologize. Sorry. Let's see. Thank you. Okay.
Have you seen that?
I'm not sure I've seen that specific document. I've definitely seen lists of labs or individuals who own or use an MVAC.
Okay, well, that's where I wanted to get. Is agencies that own an MVAC doesn't mean they use it, right?
Sure, that's good.
So when you say a majority of law enforcement agencies compared to private labs use it, you don't know how many actually use it.
Oh, I never said compared to private labs.
Let's see. Did you say, and then there's probably a larger percentage that are being used by law enforcement agencies at the scene of crime?
Yeah.
Let me back up. So you said, so there's a number of MVACs that are being used by crime laboratories, and then there's probably a larger percentage that are being used by law enforcement agencies at the scene of crime.
Correct.
So when you said crime laboratories, you were talking about public crime laboratories
Yes.
and private crime laboratories.
Yeah, just any laboratory, yes.
Okay, let's talk about some of the items that you asked to be tested. Your testimony on Thursday was that you were the one that made the request for several items from the grave to be tested, right?
It was in conjunction with the attorney. It was after I reviewed the DNA results and saw that, to Mr. Jones' credit, he attempted testing on these items. Not every lab or every analyst would have done that. So knowing that he had attempted testing and there was low amounts of DNA in some of them, I did suggest, listen, we're seeing some DNA. If we use an MVAC, we might have a better chance of getting results. So yes.
So that's a yes.
Yes.
And you wanted to you made that decision based on what you felt the perpetrator would actually grab, hold on to, etc., right?
Right, that was one of the thoughts, yes.
Where the actual perpetrator would have like friction, some kind of force to the object, right?
Right, that's, yes.
And you also included Summer's clothing, because there was some suggestions she had been sexually assaulted.
I don't know if she was sexually assaulted. I know that her clothing were found not, it appeared to be not on her body.
Okay, my question was, you asked for that because there was some suggestion that Summer may have been sexually assaulted, right? I didn't ask if you knew she was.
Okay. That can certainly be a possibility in any homicide case that sexual assault could have occurred.
And you felt that those items might have been handled by the perpetrator.
Right.
So you picked items like an electrical cord, right?
Yes.
A couple different electrical cords, right?
Yes.
And the tie-down strap, right?
Yeah, correct.
Showing you exhibit 745. A, did you request that item?
No, I did not.
And that's something that the perpetrator would have handled, right?
Actually, to be honest, I don't know if I requested this particular item or not. Yes, it would be something that was handled.
You certainly didn't receive it, right?
That's true.
And it isn't on the list of items requested, right?
I don't know the list of items requested. I definitely didn't test it. One of the reasons that I would say is that we know the MVAC is better for porous items, things with ridges. So it could have been tested, but we did not. You're correct.
There are ridges on the handle.
There are some ridges on that handle, yes.
For the record, council's referring to what has been previously referred to as the sledgehammer, which is exhibit number,
So you felt
what exhibit number is it?
745A.
Thank you.
So you felt the electrical cord would have been more porous than the handle of that hammer.
No, it was because the electrical cord had knots in it. Based upon the photos that I had seen, I knew at least one of those cords had a knot. And so that's really what I wanted to focus on. I knew that that knot was being tied.
Okay. And you knew that the perpetrator probably handled that hammer too, right?
I don't know if he did or did not. And like I said, I don't recall if I requested this item or not.
You weren't told the cause of death in this case?
I'm sure at some point I learned that. I don't know at the time of requesting items if I did or did not.
But the idea behind it was to get to the actual perpetrator, right?
Yes, and I mean, you're right. This should probably be an item that could or would be usable. I know that it had been tested for blood and there wasn't any detected. But yeah, with MVAC, it's possible we could have picked up DNA.
And it actually was tested for DNA too.
Yes, correct, and there none detected, yes.
Very low level.
Oh, an X, amylogenin, that's right, thank you.
So what you decided to pick were things, like I said, like an extension cord, which is not porous, right, but has a knot to it,
Right,
and a tie-down strap, right?
right,
And clothing.
correct.
Except for the clothing, at least the two other things are things that anyone could have touched or grabbed, right?
Objection argumentative and speculative.
Sustained calls for speculation and conclusion.
You did a demonstration here in court on Thursday with your impact, right?
Yes,
And I had an extension cord on it.
it did.
You touched the extension cord when you cleaned up?
Who touched it? I don't recall, Mr. McGee, I believe it was his extension cord,
And you had a blue strap here,
correct?
and who touched that?
I think there were multiple people who touched that.
So the two items, the electrical cord and the tie-down strap, multiple people could have touched those.
Sure, absolutely, yeah.
No objection, calls for speculation again, move to strike.
Overrule answer me.
And someone thought that those items would have a better chance of identifying the actual perpetrator than the handler.
I suggest a number of items to test, and these were the items that were approved and submitted to the lab for testing. Clothing, like I said, clothing items do have the best, clothing or fabric items have the best chance of yielding results.
Did you ask for that?
I do not recollect. I think there's a good possibility I did. I think there were a number of items I requested, but not every single item was tested.
One of the items that you can I deal with, please? One of the items that you did look at and test, I'm showing you exhibit 247. You recognize those?
Yes.
And those were received by you, item A1.
Yes, that's correct.
And you didn't have any problem identifying which item this was when you received it, right?
No.
Clearly marked. No problems identifying it. Clearly marked on the outside of the container.
I would have to look at my notes to see. So there were actually two items that were submitted as A1. And so I did have kind of an issue in trying to determine which was which. But
sorry.
oh, sorry.
I'm sorry, hold on. Deputy, can I have 24, please? To clear it. Okay, I'm sorry, Ms. White. Continue.
So this, yeah, that's much better. So this particular item, the description in the case notes matched up with the description that I was seeing, and looking at it was on the FedEx box. So the item itself did not have a barcode on it, but the box.
And a description.
Yes.
And you made some notes about the stain you see there.
I did.
And your notes were possible urine?
No.
What was it?
I said possibly bleach, question mark.
Because it looks like a bleach stain, right?
Obviously it's discolored. It could be bleach, yes.
Objection, calls for speculation.
Overrule.
Yeah. Okay. Okay, I'm going to show you a couple exhibits here. I'm going to show you what's been marked as exhibit 1009. You can take that out of the sleeve if you want.
Okay.
Are those the reported results from voting?
Yes. Yes, they are.
So those are the results that Bodie did on certain items that you sent them the impact filter for, and these are what they reported back.
Yes.
Okay. I'm going to show you exhibit number 1005, and that's what we recognize that.
Okay.
Can I see it first, counsel?
Those the known results in the San Bernardino County Crime Lab reconveyed by Bodie in their report.
No.
It's not. What is that?
This is something I'm not sure because there's no description on it, but it looks like something I very quickly typed up for the defense to have a really quick understanding of the profiles, and this is not part of the Bodie report.
Okay. Well, then did you prepare that?
I don't know for sure.
The order of the location is the same as in the Bodie report.
Yes. Yes.
Just a minute. Do you know if you typed that up?
I think so. I can't be positive because there's no identifying marks. It looks like something I would have typed up quickly to put the DNA types in order, because when you use different amplification kits, the loci or locations of the DNA tested are in different orders, so it's hard to do a one-on-one comparison.
Okay, so that does for me. The Bodie results have the first locus is D3S1358.
Yes.
D3
S.
That's 1358. And it's the same first one on the known samples.
Yes. Yes.
Actually,
Okay.
let's start with the undergarments or the panties. I don't like using that word. The underwear that were found near summer. You requested that be tested because underwear can have, and I don't mean to be crass, can have any number of biological fluids on it, right?
It can. Yes.
Can have blood,
Sure.
can have semen,
Yes.
can have fecal matter,
Sure.
urine,
Sure.
vaginal fluid,
Yes.
any number of things.
It can.
And that's the reason why you decided to test that particular item. Right?
Yes, and again, for any DNA that might have come from someone removing those items, that
Right.
item.
So any touch DNA, and I forgot to mention that.
Sure,
And even when you put your own undergarments on, you're going to have your own touch DNA on.
you can, yes.
Okay. Can I have attorney, whatever this is? 3. So that was designated as item A1, and then the filter that you sent was item A1A.
I would object to these results being put up since she did not do the testing and that have to be taken down.
I guess you would have to lay a further foundation.
Well, the court admitted a lot of testimony about Bodie's results, and the court even asked some questions about Bodie's results.
That's true, of course.
Subject to further foundation.
So based on the offer of proof that people from Bodie were going to testify as to the results.
Yeah, it's all over here tomorrow.
Well, council approach is recorded.
Carry on.
The last objection is with regard to the exhibit is sustained. You may inquire consistent with the court's guidelines.
You tested the sweatpants, right? The ones with the possible bleach on them?
I tested,
Want that up there? No.
I did test the sweatpants, yes.
And to this day, there's been no results on it.
There were no reportable results from those.
Or from Sacramento.
I would have to look at their report. I don't recollect their results.
Let's talk about the panties and the undergarments. You process those. No DNA on
Again, I have Bodie's results in front of me, and that's indicating no reportable results on the underwear. I don't recollect the cytogenetics results.
So your testimony was it's not fair for Don Jones to assume that DNA can't last that long. Yet underwear that presumably an individual wore for a period of time has no DNA.
There were no detectable DNA results, that's right.
That's Bodie and cybergenetics, right?
Again, I don't know the cytogenetic results. I just don't recollect them.
Testimony is it's not fair to assume that DNA can't last 3 years, 9 months, and 8 years, right?
Right, based upon the lack of studies, yes.
Based on lack of studies. In this case, you're aware that fingernails from the grave were tested for DNA, right?
Yes. I'm not sure all of them were, but yes, there were definitely fingernails that were tested.
Fingernails are potentially a good source of DNA, right?
They can, certainly they can be, yes.
Okay. And those results were no human DNA, right?
I would have to look back to,
Please do.
thank you. The fingernail, there was a very low level of male DNA detected in the quantitation stage only, and it was a swab from the fingernail, not the fingernail itself that was extracted, but a swab from that fingernail. And that was for A20. Then there were additionally 2 other swabs from fingernail samples, one from Summer and one from Joseph McStay Sr., and those showed no DNA detected at the quantitation level.
And there was nothing on the red strap, A25, that you tested, right?
I'm sorry, Vic, objection to Vegas, which test he's referring to?
Overall.
A partial profile was developed.
On A25.
Yes.
Is there another red strap where there was no results?
One moment. Yes, that would have been my number E12A.
E12A, okay. So another red strap didn't have any DNA on it. Essentially, the results you got back from Bodie showed DNA on how many different items? Potential DNA.
The results that I got back from Bodie showed DNA at some level on 4 of the items.
The rest of the items that you submitted were 9 total?
Well, ye- 9 that we've been discussing, yes. There were 10, but I believe 1 was found to be unrelated.
One was found what?
To be unrelated
Okay,
to the case.
you're
So,
right, okay. But 9 that were relevant to the case.
yes.
And you were asking questions about the judge, about how many different locations on those 4 items being a result of the wheels, right?
Yes.
Okay. Now, how many different locations was Bodie looking at?
They did global filer, which is, there's a total of 24 loci or locations, but 2 of those are specific to males only. So if you have a female, you would never see those particular loci.
So 22.
Sure, yes.
Okay. And how many, for the known samples, how many locations are there?
I believe 16, because they were run with a different kit. They were run with something called Identifier Plus, and there were fewer loci for those particular samples.
Okay. So you might have a result from an evidence sample, but nothing to compare it to on the known sample.
That's fair to say, yes.
So some of the locations that the judge was questioning you about may not have results that are comparable on the known sample.
That's true.
When we're talking about touch DNA, we're talking about a very low level.
Typically, yes.
And you said that your opinion that it's not fair to say that DNA can't survive 3 years, 9 months. It's based in part on a study that was done on different types of soil. Right, samples in different types of soil.
Right, so I did mention that study. I wouldn't necessarily say my opinion is based upon that because they only did out to 90 days. So I said the closest I could even come to finding anything relevant was that particular study. But again, they only tested to 90 days, so.
And blood has substantially more DNA in it than touch.
Absolutely, and they were using blood in those studies.
So if you have a touch DNA sample, because it's it's usually a lower level amount, it's going to degrade faster. Right?
It could, yes.
It does. I mean, it makes
Well,
sense,
it's
right?
it could degrade. I would assume it would degrade at the same rate, but if there's more DNA present in a blood or saliva sample, then you might have more DNA left over to get results, as opposed to a touch DNA sample where there's less DNA to start with. So it's not necessarily the degradation rate, it's kind of the amount of DNA that we're starting with.
And even using blood, which has a lot of good, strong source of DNA, after only 90 days, a lot of it is significantly degraded.
They did note they were seeing degradation, yes.
Significant degradation.
Yeah, I think they said highly, or it might have been significant, yes.
And that was the closest you could find to support your opinion that touch DNA can survive 3 years, 9 months of degradation.
Right, and I don't know if my opinion is that it definitely will survive. It is, I'm not sure if it does or doesn't because there aren't studies to support that. I can say that we have results in this case.
The other study that you discussed was one that Tom Jones discussed that was done with body.
I believe it's the same article, Emmons.
Sounds right. And they left 4 different bodies out and they tested the soil around the body, or underneath the body.
Yes.
And you were asked questions on direct as to whether or not being buried is different than laying on top of the soil.
Right.
And you said yes, you believe it would.
I believe it would be yes.
Why?
exposed to the elements, there's going to be different rates of degradation of a individual, whether they're buried or exposed to the elements.
When a body decomposes, it goes through 4 or 5 different stages, right?
It does based upon the articles I read, but that's not my area of expertise.
I understand. But when it does that, it essentially becomes liquid, right? I mean, the body will essentially lose all of its water, and decomposition fluid will flow down.
True.
So if you're studying the soil, that's a good place to start underneath the body because of gravity.
Sure.
And is there really a difference whether the body's on top of the soil or underneath the soil? Gravity's still going to pull the decomposition fluid down, right?
Right. I think, on top of the soil, you have possible predation, you have blowflies, you have, things like that that are going to affect, again, the rate of decomposition. But again, I don't want to stray too far into that because it's not really my expertise. I'm a DNA analyst.
Okay.
So
But in that study, they couldn't find any nuclear DNA in the soil.
they were looking for I believe they were looking for mitochondrial DNA. No, I could go back and double check that one. There were a couple of different ones that were similar, and one they looked for mitochondrial, but it was with pig DNA.
This page is without work, so I'm sure it is.
Okay.
Can I see it, counsel?
We'll go ahead and take our afternoon recess, this time 15 minutes. Keep in mind the admonitions previously given to you in the form or express any opinions about the case notes.